The evidence by the prosecution against the second accused person did not place the second accused person in the house of the deceased on the material night. There was no evidence that she had ever communicated with the deceased. The evidence that the prosecution have brought before this court on the second accused person relates to the events of 20th of September 2018, and that is the shooting incident. And in that regard, having considered the provisions of Section 129 of the Penal Code of Kenya, and the second accused person having had no objection to her two statements which she gave the police. One saying that the second accused person, the first accused, was shot in the house, and then retracting that statement the following day, only leads this court to the provisions of Section 129 of the Penal Code, which states as follows. That Section 128 creates an offense, which is an offense of giving information, false information, to a person employed in public service, and states as follows. Whoever gives to any person employed in public service any information which he knows or believes to be false, intending thereby to cause or knowing it to be likely that he will thereby cause the person employed in public service A, to do or omit to do something which the person employed in public service ought not to do or omit, if true state of facts respecting which such information is given were known to him, or two, to use lawful power of the person employed in public service to the injury or annoyance of another, is guilty of a misdemeanor and liable to imprisonment for 3 years. The statement which the second accused person gave to the police on 28th was false. The statement was given to a person in public service. The statement intended that that person investigates that offense. That statement was retracted by the second accused person the following day by a different statement now speaking to what is said to be the truth. There is no timelines in criminal law when you can prefer a charge against a suspect. The Limitation of Actions Act does not apply to criminal offenses. It is my considered view that the charge brought against the second accused person was not the proper charge. Section 157, sorry, not section, Article 157 gives the power to institute and prosecute a person suspected of committing the offense to the office of the Director of Public Prosecution. And the question posed at this stage is, was there an offense committed when the second accused person gave a statement to the investigating officers at Langata Police Station, which turned out to be not true? I say no more. The office of the Director of Public Prosecution know their mandate. The result is that the prosecution did not adduce adequate evidence for this court to find the second accused person guilty of the offense of murder of Monica Nyawira Kimani on the night of 19th of September 2018. The first accused person is convicted on the charge. The second accused person is acquitted of the offense.